All right, so I came across a video today in my normal feed where Steve Lehto of Lehto's Law is posing the question of what is jurisdiction? And this is a topic we talk about a lot. And his take on it was decidedly different than what we generally discuss and what we generally find, and also what we generally find that comes up in court itself. Not what comes up to lawyers outside of court, but rather what actually kind of is discussed in court when this is discussed. So we thought we'd go through the video and kind of pause it and chat about what he's asserting and what we've seen maybe and some different takes on it. So there's a couple things we want to preface with because Lehto is going to strawman a bit. He's gonna presume his opposition to have certain positions, and we don't share the positions that he kind of makes as his counter. So they end up being a bit of a straw man compared to what we would generally advocate or discuss or think about it as. Well, there's a couple key points. Let's see here. Firstly, just to get out there, sovereign citizens and generally what's ascribed to them is generally a mistaken thinking. Mainly because it's assertive. It's an assertion of what is or should be without any real evidence to back up that assertion. Well, how would you generally describe the sovereign citizen assertion there?
Oh, there's a couple of different levels. What first comes to mind is they basically are trying to expose some corruption, let's call it for lack of a better phrase, through making up their own story. They don't like the existing story, so they make up one of their own and then compete these two narratives against each other. And what we do, and this is all Socrates, this is all the Socratic method of investigation, is simply clarify the assertions that the state, the government, the courts, the judges, the lawyers are making. We don't need to make an argument, don't need to make a claim, don't need to make any assertions. Therefore, you don't take on the burden of proof. So to me, I'm kind of zooming out here a little bit. Sovereign citizens do this, and a lot of other groups do this. I was in Hawaii. They've got their own story that they like to compete against the governments. And they don't recognize the power in the Socratic method. They don't recognize the power in forcing your opposition to clarify their statements and hold them against the lens of logic and ethics and factual evidence. And so, to me, that's the biggest mistake they make. Then I would go down, well, they make these other mistakes because they're using this as a definition for sovereign and this as a definition for citizen, and these two competing inconsistencies aren't going to jive in a nutshell.
All right, well, you mentioned burden of proof there, and that's kind of a bit of a crux issue. So when would a burden of proof matter? I mean, we're not talking about just in chatting with a lawyer, obviously.
No, there's impositions being made against people that they claim are presumed innocent. So if you're threatening somebody with stealing their money or sending them to jail or giving them conditions that make life extraordinarily difficult, the ability to keep a license, a job, family situation, custody, all kinds of things are going on. If you're looking to impose upon someone, jurisdiction matters. That's when it matters.
All right. Well, why would a sovereign citizen have a burden of proof, and why wouldn't we? What's the difference between the sovereign citizen and what what we're going to talk about.
Well, again, they've got a story to sell. They come up with assertions, and when you do that, you assume the burden of proof, and they call it a burden for a reason. It's heavy. You shouldn't want it. It should be like a hot potato. And they don't see the value in this. They see a lot of. We're not taught this in school. We're taught, from the lowest levels to the highest. Even the presidential debates do this. It's just argue, argue, argue. That's what, if you go on a debate team, is just argue, argue, argue. Instead of, okay, you're claiming this. Well, let's challenge this and see if it can withstand basic, not anything complicated, logic and ethics, and if it's consistent. To me, that's the difference. They take on a burden of proof unnecessarily, shoot themselves in the foot. They are not able to generate the kind of public and therefore political pressure that we can, because they come off as they're just trying to be an exception to the law, to the rules. Where's their proof of their claims? How come sovereign is this and not what the government says, and a citizen is this and not what the government says? And so the fence-sitting, third-party objective public that we're trying to convince are not convinced nearly as much by sovereign citizens as by someone who's just looking to clarify what the government is saying it's doing and why.
Well, why would a prosecutor need to worry about clarifying anything beyond just handing you the ticket or maybe some indictment?
So the prosecutors are highly motivated to maintain what they call, quote unquote, the integrity of the judiciary. They're obviously subservient to a judge, and quite often their career progression and standing is according to the opinions of judges. I mean, most judges are former prosecutors, I would say. Would you say that's true?
Yeah.
Okay. So they have a career path to make, right? They've got ambition, and it's very, very important to them that this process, and everything's being recorded, by the way, most times, is seen as legitimate to the average Joe Q public sitting and observing, or reading this later in transcripts, or watching this on YouTube or social media. Very, very, every bit is like a salesperson who's selling a car. They want you to see that, look how awesome their cars are. So they put it all forward. Someone coming in that is effectively exposing the truth of the situation, which is that all they have is might makes right authority. They rule because they have the guns and the paid bribe guns, and they use them. I mean, we're not naive. We realize life is violent. There's violence in the world, and this is just well-hidden violence. So to answer your question, prosecutors are very, very concerned about their public image and the court's image.
All right. All right. Maybe also tying in a little bit of that whole right to be informed that is kind of like a factor in putting someone on trial. But we'll get into that in a little bit here. All right. I also want to mention that maritime law and commerce and constitutions really don't play a huge factor here.
Commercial codes.
Yeah. Most of the distinction between jurisdiction, as we'll kind of end up kind of describing it and thinking about it, and the way Lehto conceptualizes it here in the video that we'll view in a second, boils down to the difference between after all of these politics and before all of these politics. The various little branches in between really don't factor into the difference between Lehto and Socratic approach to that same. Also want to mention that threats of violence isn't a valid way to get rid of an objection. If you raise an objection and someone threatens you with violence in order to get that objection ignored or get you to quote unquote withdraw the objection, that doesn't logically or ethically handle the objection. That's kind of, I just want to put that out there now because it's going to come up as being a big factor in the difference between our positions on jurisdiction.
And we should mention too, if you go on the About Me tab of Steve's page, you'll find out a little bit about him. Just keep in mind, this is a guy who's been practicing law as a lawyer for 27 years in Michigan, and this Steve guy is extremely typical. Like virtually all lawyers will agree with everything he's saying. Maybe for slight, subtle, different reasons in some areas, but just to be sure, this is not just one lawyer out of a million. They are almost all like this. So,
With one exception, if you're actually in an arraignment situation and you come down to a question about a certain point of issue, we'll kind of discuss later. Suddenly, all of these lawyers will do an about face on the topic. In that one instance, we'll talk about it in a little bit when we get to that point.
they get quiet. They stop talking and get real quiet.
Yeah, suddenly their assertions aren't as appropriate anymore.
They
in
let the
that
judge
scenario.
handle it.
Yeah. All right, let's fire up the video.
Today we're going to talk about jurisdiction. What is jurisdiction and why is it so important? If you poke around on the internet, you'll see that a lot of people are confused by jurisdiction. You'll often see someone at the side of the road yelling at a cop, "You have no jurisdiction over me." Or occasionally you'll see that same person after they're arrested in court yelling at the judge, "You have no jurisdiction over me." And of course the question then becomes, what is jurisdiction? So here's the problem. Many people either don't know what it is or they're confused by it. But jurisdiction, generally speaking, is the authority given to a court by law for that court to either try cases or rule on legal matters.
All right. So here we already started. He uses the phrase by law, and I don't really know at this point, nor does he clarify too well what he means by that.
That's exactly by design.
In retrospect, I think he's just using that as shorthand for legislative intent, what the legislature wants. But it's always used as a bit of a placeholder of stop arguing, take this as a settled thing. Law is like by stop arguing intent. It's a fuzzy thing designed to get rid of any objections. But that's not good Socratics. To let that just kind of get rid of objections and so forth is not. By law is not a good reason, not a good argument, and not good evidence.
Oh yeah, it's just a vague, fuzzy word. If he should just say because of the statutes and codes, because that they actually have written down and call them statutes and codes, but they don't write anything down and then call it a law. Of course, it can't be that specific, because people would be like, wait, statutes and codes, and those are applicable to me exactly how? But law, oh, no further explanation needed. I've watched Law and Order. I know exactly what's up.
And the jurisdiction of most courts is limited in some way or another, okay? And we'll get to that. But generally speaking, jurisdiction is simply whether or not a court can hear a particular kind of case.
Court can hear whatever case it wants. They have the guns and arrest warrants. Can is just the wrong word there.
Yeah, can leaves it up as like a physical ability.
Right.
So the question that begs, of course, is do you mean physically, or ethically, or just according to what the lawmakers kind of describe? It's like if your boss says it's okay, I guess that means you can. But again, this is completely revolving around his own notion of what jurisdiction is, which we'll kind of get into a little bit better. All right. So we're going to see him chat about a hypothetical instance for a little while. I'm going to go ahead and skip that.
It's not even a good analogy.
It's not even a good analogy. So he just comes up with an analogy of a fraud in a car sale.
He's selling a car. Guy sold him a stolen car.
All right. Well, let's just blow on by that there and get to right here.
But also, how do you get jurisdiction over somebody? In other words, you can't just walk into court and file the lawsuit and then have a hearing. I've got to be served with a summons and complaint to let me know that I'm being sued. And so you have to have that summons and complaint served on me. And once I've been served with it properly, the court now has jurisdiction over me. So if I don't.
All right. So,
Failure to state a case.
yeah, failure to state a case. That gets instantly pretty big, doesn't it, though? Okay, so one of the things a court acknowledges it needs in order to assert jurisdiction is a case, a stated case, even. So in all this, the failure to state a case isn't something that Lehto's going to really mention at all. But it's not. Most lawyers want to call it, well, if I say this court has jurisdiction, that satisfies that part of stating a case. So a stated case is just outlining how you know that your adversary is in the wrong, I guess. That's kind of rough.
How imposing upon them with a court date is justified.
Right. Now, ethically justified, not merely legally. Now, both. Let me correct that. So, substantively justified, which means more like ethically or not merely with procedure, and procedurally justified. So we have the whole substantive justice and procedural justice, both needing to be satisfied in stating a case. And there's a procedural needs, and if you fail to do that, you failed. And then there's a substantive problem of stating a case, meaning that you've stated the facts that would, if true, mean that that it is justified to impose on the adversary. Now that's very rare, I would say,
Right.
In some courts.
It would be nice, ideally, just to clarify, if they would hand you notice plus the factual evidence. Jurisdictional evidence, something that pertained to that element, whether or not there's an actual victim, how much they're alleging they were harmed. I mean, just so that you could look at this documentation and be like, oh, this is justice. I am responsible to show up and defend this or respond to it or in whatever way. But no, of course he's not going to discuss anything like that. It's just you are now given a time and a place of our choosing to show up, and if you don't, we're going to rule in your absence and everything that means. And notification is all it takes. No substantive anything about anything else, just notification, and you're automatically threatened.
Now, funny thing is, if you try to quote unquote serve someone with enough political clout, you'll instantly find that your service, your summons or whatever, I think it's quashed. You'll find they just fail, motion for failure to state a case, and you'll probably never even see the inside of a court before you get to the point of being done.
I probably won't even take your filing.
Well, that too. But it's funny how one directional that that little habit is. But all right, just wanted to stop there.
So yeah, it's a bit more than service if things were the way they should be, but.
And it's a bit more than service when it's someone with political clout on the other end.
Show up for court, it doesn't matter. You can default me and get a good judgment against me. And if I do show up for court, the reason I'm there is the court has jurisdiction over a claim against me, and I want to show up and see what I can do to make, something good happen with this versus something bad happen. So.
Oh boy. All right. So the idea that people would sincerely be worried about the brutal threat that not going along with a court document. You're just here to do your civic duty, and because the court has jurisdiction is why you showed up as a result. I that's just delusional is the only way I can describe that.
Well, yeah, it's very convenient. I mean, again, this is a guy who makes his living on this system, so he's highly motivated to remain in a self-deluded at best state, or just a straight dishonest one at worst, probably, about this issue, about this reasoning. It's all, well, they just have jurisdiction. How do I say this? It's more comfortable to live the life of the sheep if there are no wolves around. So they just la 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 la. There are no wolves in the world. Oh, everyone's just kind of the same like me. Oh, okay, yeah, this is fair. This is good. Let's go.
Yeah.
Jurisdiction can also refer to whether or not the court has the authority to hear a claim regarding a specific party. So, interestingly enough, if I lived...
Well, I'm not making it very far without having something to say, huh?
He's given multiple definitions, multiple contexts of what jurisdiction is.
So
I think a lawyer would have a good answer to that, a standard answer to that. But.
well, they should. Let's bring this up here. So let's have a look here. All right, here we have a couple of different types or subcategories. Not types. Types is a bad way to think about it, but subcategories of jurisdiction. And so we have a few, and any flaw in any of these subcategories would mean that you don't have jurisdiction. To have jurisdiction means to be in the right on something. So if there's any flaw with being in the right, it means you're not in the right. It's not that any checkbox in any column gets them jurisdiction. It's the other way around. So we have in personam jurisdiction, jurisdiction meaning it is right to control a person or impose on a person. We have territorial, which means it's right to assert jurisdiction in a certain area. But that doesn't mean, again, you'd have to have both. It would have to both be right for you to impose on a person and within the territory. We have subject matter jurisdiction, where certain courts only address certain issues and certain subjects. And in the U.S., they're supposed to have a case or controversy, which is a big factor in having subject matter jurisdiction. That's usually the one that's most ignored, unfortunately. In rem is just when you have right control, or you can rightly impose upon a piece of property. And there's still, like in some parts of the world, and certainly through history, there's been ecclesiastical jurisdiction where there was a religious component or a church component that really doesn't hold much in the U.S. in the modern era. But he's talking about in personam jurisdiction here and a bit of territorial, and saying that, well, since we got one in a kind of in a way, and since we've addressed one instance or one part of one, we're good. Oh, we even addressed another part of another, we're still good. Oh, we've even addressed a certain part of subject matter, we're still good. The chore to show that you have jurisdiction is to show that there is no flaw anywhere in your assertion, not merely that there's no flaw in some sub part of your assertion. But I guess it's common, and it's a shame, because I mean you boil down to it, or you get to the root of it, and most attorneys do know the construct of this in discussions, but they'll be all over the place in a formal setting or in a formal discussion, which just kind of shows that there's not much sincerity or forthrightness going on.
It's all just hiding the elephant in the room. Everyone sees this elephant in the room. Like, people would not pay taxes if they didn't have to. They have to because of the threat of the gun. They'll steal your stuff or they'll put you in jail. Everyone knows that government actions are done with coercive threats of violence. And it's the exact same thing in a courtroom. And, they're not going to address that at all. And if you bring it up, by golly, you will see more tactics of diversion and deflection than you've ever seen before. It's just, they know what's really going on, but they won't talk about it. They have to sell it as justice.
In a formal setting, it's a little different than in an informal setting. Different distractions, different diversions, I guess.
Yeah.
Interestingly.
Oh, yeah. If you're in an office with attorney-client privilege and you're just BSing with your lawyer, if you really push the matter, they'll let you know. Oh, you're right. They will do this. They will take this action against you, and this is how it will be, and that's why it's done that way. Get used to it. Welcome to the real world. What are you, a simple-minded, naive child? That's their attitude about it. But, of course, in court, no. They'll never admit that truth in court. So the evidence is everywhere, really.
All right, let's fire this back.
In this county, and I stay in this county. I've been living here my entire life, and I never move out of this county. If I'm never served the summons and complaint, the court does not have jurisdiction over me. Okay? But the court can very easily acquire jurisdiction over me by having someone file a summons and complaint on me. But here's the thing. More often than not, we're talking about the jurisdiction that arises when you get pulled over by a police officer, for instance. So you should know that.
So now jurisdiction is satisfied by the service.
Well, by
Of the summonings.
by arising from a police officer pulling you over. So if the police officer didn't manage to pull you over, there wouldn't have been jurisdiction. I mean, nonsense. Of course, it's never been that way.
Right.
It didn't arise from it. It might have been first asserted by the presumptions of a cop, and that cop certainly in his mind felt that he had jurisdiction, but he felt he had jurisdiction, right, wrong, indifferent. He feels he has jurisdiction over anybody in his reach.
Oh, yeah. He's trained that way from day one.
Right. It's like you have jurisdiction over everybody within borders, probably, or something along those lines.
This lawyer's treating jurisdiction like it's some fickle thing, like a light switch that can go on and off. I mean, let's look at how the military handles jurisdictional issue. They get your signature, which still isn't legitimate because you're so unaware of actually what you're giving this false consent to. But anyway, they get the service members' agreement by signature and their documents when they first come on active duty or whatnot, and that's why they're under the UCMJ. And there's no question about if a military cop pulls you over, oh, now he has jurisdiction, and or the borders of this base, commit a murder or commit adultery off base and see what jurisdiction is held over you.
Yeah, that jurisdiction didn't arise because the MP pulled you over. That happened suddenly when you signed up.
Right. It is.
They don't need.
It is everywhere. It follows you
Yeah.
wherever you go. This jurisdiction should be a just system. Should be something like that. It's not this fickle thing that goes on.
Yeah, and if you ask, does a military court have jurisdiction? They'll pull out your own signature.
Yeah. There you go.
Now
You
it's like
agree.
if you say that it wasn't me that signed, then suddenly you have a discussion to have, and then they'll probably if you didn't sign up, like let's say you have a twin brother or something like that, they'll be like, we're so sorry to have mistakenly tried to assert jurisdiction
Right.
over you. It's not, oh, well, the MP pulled you over, so we had it.
Right. So again, why the inconsistency from the military to the civilian side of the game?
No signature.
Because they know.
And it's not that agreement's what's needed.
Consent would be nice.
Well, consent would be one way. Well, we get into that in a
Yeah.
minute here. Let's get on a few seconds here.
That all of the issues regarding jurisdiction arise from statute. In fact,
Okay.
Well, there we have it. And I think we agree. I think all of the issues and disagreements that we have with Lehto here arise from the reverence of statute.
The Bible's true because the Bible says it's true.
So,
Perfect logic.
but we just basically moved the issue a little bit here. So, jurisdiction is the only thing in question, the jurisdiction of the court, and not the jurisdiction of the legislature, when you're arraigned, is it a given that the legislature had jurisdiction?
No, they'll assume that all day long.
Well, okay. So since when in court are there givens? Is it challengeable? So I guess we're talking about a pre-political issue about jurisdiction, maybe called a natural law or interest of justice. We're talking about can a statutory construction be against ethics and be just?
It could be both.
So it could be against ethics and be just?
No.
Oh.
Like either. It could be either one or the other. I guess I wasn't following your
Okay.
point. No, it can't be both simultaneously.
All right. So, and I guess I'm kind of making an association that justice and ethics are associated and can't be in contrast. If anybody wants to construe that justice and ethics aren't related or can be opposite of each other, I'd love to hear that argument or love to address that argument. That'd actually be a very good exercise.
And keep in mind, too, this is just for the viewers' understanding. This is all like 2-year-old level ethics. Like, I can't, steal money from you for no reason. I can't punch you in the face for no reason. This is not any kind of complicated, controversial type of level of ethics.
Even if that reason is that I wrote down that I may, if I write down that I get to rob you,
Yeah, that's what they're using. I wrote it down, so it's legit.
There's a little shout out to Larkin Rose for the I Get to Rob You video. I certainly would suggest people look that up. But, okay, so when you're accused, is statutory applicability an essential element in that accusation? I mean, so the applicability of the decrees of a legislature, is that what's called an essential element? Something that must be true in order for you to be guilty. And these things are supposed to be proven. Like all essential elements of an accusation there should be a burden of proof to show that those are right. And here we have, well, this lawyer and most lawyers and most prosecuting attorneys presuming, well, hell, they usually presume the full-on jurisdiction of the court. If they feel like the court has it, they just presume it, and aren't real concerned with proving anything.
Their paychecks depend on it.
Yeah. But, well, it's like, okay, well, you want us to prove it? We'll prove that we've satisfied the statute. But proving that the statute is relevant is left completely off the table.
Yeah. See, and this brings up another distinction between us and all other groups I'm aware of that resist government impositions through courts. And that is that, yeah, sure, we could go through a process to try and prove something we're saying, but it's ultimately not necessary, because all we're clarifying is if they've actually addressed the issue at all formally on the record. Like, they're acting as if they have jurisdiction, and they'll threaten and all that. But when asked to provide any factual evidence about the link, the connection of the dots between what we wrote down on paper and what we're going to mess up your life with, they are silent, and they will threaten you if you bring up that point. So to summarize, it's not, let me look at what you've got so I can make a determination on it. It's, have you even turned in anything at all whatsoever regarding the issue? That's just a yes or no. I don't need to look at what you've turned in. I just want to know if you have turned something in regarding jurisdiction.
Okay, so let me unpack that for just a second, because all right. So the first question, again, getting at wanting to see the evidence is always a good thing. But even before that, the question on the table is there factual evidence of the truth of some piece of what you're accused of? And that piece is there any evidence that the legislated decrees apply to me, to the accused? Now, like you said, that's a yes or no question. But all they would have to say, if it were not needed, is that there is none, and we don't care,
We don't need it,
and we don't need it.
but they'll never say that.
That's very rare.
Have you heard someone?
Well, in a civil instance,
Oh, yeah.
a lawyer accidentally said that, and he lost, of course. That's one of my prize moments.
Ending your involvement in a civil action you should have never been a part of in the first place.
Right.
On the spot ending it.
Well, it was still some fight because,
Oh, was it?
it was months of letters back and forth. No fair takebacks. So, the point is that there's a double bind involved. In casual conversation, they'll say no evidence is needed. It's foolish to bring it up. Bringing it up will just result in the judge, saying it's not needed and moving on. And sometimes it does result in that. But the issue needn't go away. And certainly we've seen and caused many instances of people sticking to that point and sticking on that objection. And the consequence of that, there is no evidence of an essential element of an accusation, and that's a problem. That's a logical problem.
To those who would
And they
be-
admit
go
it.
ahead.
Oh, and they admit if they should admit that there is no evidence of jurisdiction, without just like a non sequitur, like we can provide evidence of his location or something like that, which we'll actually kind of see him get into a bit. But the non sequitur that results in is a bit of a trouble.
Boy, it is. What I was going to add real quick was to those who would say, oh, you're just being rude to the judge, you're being problematic, difficult, why do you keep having to bring this up? All we're trying to do is something that they freely admit we have the right to do, which is to be informed of the cause and nature of the charges and proceedings against us. So we're following their own rule book,
Right.
and they hypocritically say, you can be informed of what's convenient for us to inform you of. All these other wishy-washy labels out here, we'll call that now you're informed. But when it comes to any element of jurisdiction that we, again, will admit that you are presumed innocent of, oh, hell no. You're not going to pull back the curtain and expose what's the magic show we're doing as a hustle against these people on my watch. Sorry.
Yep. All right, let's try to get through a few more seconds here.
We got to get these hand cameras up and going, man. Because it'd be cool.
All right, let's go a little further.
Expect that every state's going to have similar statutes to these. But in Michigan, all this is found in the Revised Judicature Act, MCL 600 et sec, which you learned about a couple videos ago. General personal jurisdiction over an individual. People, like me. The existence of any of the following relationships between an individual and the state shall constitute a sufficient basis of jurisdiction to enable the courts of record of this state to exercise general personal jurisdiction over the individual or his representative, and to enable such courts to render personal judgments against the individual or representative. So number one is presence in the state at the time when process is served. Okay? So I'm sitting in my house, you walk over serving the process, and I'm in Michigan, guess what? The court's got jurisdiction over me. This all
Hey, guess what? Is that all?
Closed case.
All right, so he asserts that because the legislature decreed, then it's so. And again, it presumes that the statute's applicable. And I think that the thing is that because sovereign citizens generally also share that assertion that statutes always apply or statutes are applicable. They just differ in some kind of a construction. Like they differ on how it's constructed and to what situations it would be applied. And they put themselves in some kind of a exempt status, and that's an issue for kind of a trial issue, I guess you'd say.
Well, also
He's presuming it.
Sorry. Well, also often drawing upon some parts of a constitution to do so. And the funny thing is that the Constitution, the Lysander Spooner point, has either enabled this system of legalized domestic terrorism, or it's been powerless to prevent it. But either way, it seems pretty worthless to me. So it's funny when these sovsits and other constitutional types will, oh, hey, I'm standing on this and standing on this, and that's not in line with the Constitution, therefore I'm right, you're wrong. Like, it needs to be convincing to average Joe Q public if it's going to be powerful. And if they're not convinced by your counter assertions, what are we doing here? I don't know, it's pretty funny to me.
So yeah, so far the difference here is that he's asserting that the legislature can dictate jurisdiction and can assign it to the court, and it's just a matter of satisfying the legislature's requirements or procedures for that. And the question becomes, what principle is that based on? And if it's just that might makes right, let us know. Don't try to say that this is based upon some fundamental, natural law or some pre-political, law. That if this is just might makes right, then let us know. But that can be addressed separately. If it's might makes right, and a court goes down with that kind of a assertion, it can be addressed. And they don't want it addressed on those terms, of course.
No, they'll say, oh, if you don't like it, go run for office. Go vote for somebody that'll do different.
Appeal it. Yeah. Go become legislative.
Yeah. Go through only acceptable forms of resistance that will and have always still kept us in power. Go ahead and do that.
Also means, by the way, as you can imagine, if somebody had a claim against you for something, but you live in another state, and you foolishly came to Michigan on business and I found out, I could find out where you're staying, run down and serve you. And it might be the only day you're going to be in Michigan your entire life. But you were here, jurisdiction's good. Number 2, domicile in the state at the time when process is served. So let's suppose you come by my house and I'm not there. I'm down in Florida, or I'm in Guam. And you can come up to my house, and I'm not here, but can you get jurisdiction over me? Yeah, you can, but you'll still have to serve me. But the funny thing is, I believe they could serve me in Guam if they found out that's where I was. Serve me in Guam, but it doesn't matter because domicile in the state at the time when process is served. That's good.
All right, a bit to unpack there, huh?
These servers, the service has all kinds of power in Steve's universe.
Yeah. So what if someone doesn't concede that point? So it comes back down to, if someone doesn't concede the point that he's basing it on, which is that the legislature has a right to, dictate what court has jurisdiction and when a court has jurisdiction, then what happens? What happens when someone's not willing to concede that? There's a principle that, okay, they just line up the evidence to show that they're correct and you're incorrect and move on. Yeah. But see, that's again the difference between pre-political, justice and being under a political system. I guess we kind of belabor that point, but let's go ahead and let him go on. I just wanted to. There's a lot to unpack, but it's just all built upon the same presumption either way.
Failure to state a case.
And number 3 is consent, to the extent authorized by the consent and subject to limitations provided, blah, 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 blah. So in other words, if you had somebody who's not in Michigan, never planning on being in Michigan, but you said, hey, look, I want to sue you, and I want to sue you in Michigan. I can come down there and sue you where you are, but let's just suppose that you're magnanimous, or you just don't care. You could say, fine, I'll accept service. I'll consent to jurisdiction in Michigan, and if you consent to it, then you're subject to the laws and to the summons and so on. Now, here's the funny part.
Why would anybody do that?
Well, I mean, if two people are both in the other state, it would make sense for them to consent and save themselves trouble of, maybe traveling or something. All right. So arguing merits, like going into the details of what you're accused of and bickering about it, either yourself or with an attorney, that would logically be consent. It makes perfect sense that if you're drudging into the details of an accusation, not just to clarify what you're accused of, but rather to bicker about them, making any assertion whatsoever, that is, it's logical that you're consenting to the process. I just wanted to kind of put that out here, since kind of consent is being discussed. But consent's just a minor issue. And of course, consent, it's hard to have the word consent in the middle of a sentence where there's guns involved, where there's a gun in the room and a threat of violence involved. The idea of consent is nonsense. Literally, a gun in the room isn't what does it. It's the fact that there's a threat present. That's what I mean.
It's really shocking to me, too, because, consent has been such a talked about word, such a buzzword in the whole, false rape charges epidemic kind of getting floated out there, people having their lives ruined on social media with no police report or courtroom ever being seen. Consent, 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 consent. When it comes to sex, boy, consent is everything. And they detail it so much that they're just, a little bit of a side point here, but they're trying to make more and more and more activities be a lack of consent. And yet, when you apply this to the legal system, nobody, where's the talk about that? The consent of the governed is even a phrase. There's no consent whatsoever, anything to do with a courtroom or a judge or a lawyer, without a properly stated case, without being informed of the cause of nature, without a presumption of innocence, and without due process. There's no consent, there's no legitimacy, there's no judges or lawyers. It's just actors and costumes.
I think they're saying that if you participate in society, in political society in any way, that's essentially consent. Ignoring the fact that any bucking of their any bucking of their systems will result in you being brutalized, pretty instantly.
And an example of.
Yeah. Let's get a little further here.
Okay.
A lot of times when you see people complaining about jurisdiction, they'll say, I don't consent to jurisdiction. Well, if you just follow the logic of what I just read to you, there's 3 ways they can get personal jurisdiction.
Okay. Well, I mean, that's what we were talking about, is consent.
Does the military use any of those 3 ways?
Well, and he's talking about he's talking about someone objecting with an assertion, with a counter assertion.
Right.
It's like, oh, well, God forbid you challenge it and say, hey, how do you prove what you're saying? And lawyers really love an opponent who makes a counter assertion. It really gives them a pass.
Oh, yeah.
In fact, you'll see whenever somebody's trying to make a challenge that the judge and adversarial, the other side, the lawyers and the judges will just try to manipulate the situation into one where instead of a challenge, you're making an assertion.
You can shoot it down.
Yeah. Then it's a matter for trial, or it's a matter to be adjudicated or judged. So making an assertion to a judge and arguing just begs for them to decide between your assertion and their assertion. And that's a horrible, horrible idea if you're not talking about something the judge is going to want to see happen. And the judges are very political. It's a political position, and it's part of the political structure. It's where his power comes from. The idea that a judge is going to suddenly, like, I don't know, go against his own power structures and denounce his own, political structure is just not. And there's no magic words. I mean, sovereign citizens sometimes come up with the idea that, if you just, I don't know, look. You do a certain hand motion to him, or if you look over your glasses at him. I've heard strange things, but suddenly if you get this judge to regard you as a human being rather than a abstraction embodiment of a personhood, if you're a man instead of a person, and all of that cuts down to just conceptions of kind of fictions versus reality. And I'm certainly all for dispensing with fictions, but you can't hold on to half of them. You got to get rid of all of them. You got to get rid of the fictions and talk about reality on reality's terms, and not say, "Oh well, I'm gonna hold on to this political fiction and get rid of that political fiction and try to make sense of the world through that." That's where the sovereign citizen has a horrible time.
It's a tempting thing to do, just being a human being.
Oh, yeah.
You want to create a competing narrative.
Right.
And then battle, go to battle that way. It almost comes second nature. It's kind of weird when people go, no, you just got to clarify their positions. You're like, what?
Yeah. Yeah, Socratics is not hardwired. Right. It takes a lot of work to get to being able to approach something in a Socratic method, and not to just make a counter assertion.
Yeah, but it is by far the most effective. Like, second place is a distant second place.
Yeah. Yeah, nuh-uh is almost one of our favorite words. I mean,
Just staying away from logical fallacies, insults, raised voices, interrupting, and just using a Socratic method of investigation has the highest chance to actually begin to change a person's mind, which is to say have them start to change their own mind than anything else out there.
All right, let's get a few more seconds in here.
Diction over you right off the bat. The third of which is consent. So that means that the other two don't require consent. So if you come up to my door or knock on my door and I open the door and you say, boom, congratulations, you've been served. I don't have to go, I don't consent to this. I don't have to say, I do consent to this. Doesn't matter what I say. I've been served.
That's true. If you do wrong, if you're guilty of harming another person, consent doesn't come into what he's limited to doing to get justice for himself. That's fundamentally true. Now, consent's a good way to not have to worry about it. So if you're accusing someone who might be guilty and might be innocent, consent is a damn good way to bypass the whole question. Yeah. And we've seen that. I mean, if but see, that's the thing. At arraignment, has guilt been proven? I mean, nope. and so without proving guilt, how do you prove jurisdiction? And it's a burden.
With guns.
So that is the burden at hand, is at arraignment or at the outset, threshold issue is jurisdiction. And you don't get to reach into the end of the trial. You don't just say, well, we'll just pretend we have it, and then if we did, fine, and if we didn't, we just screwed somebody over and no big deal. So I'm going to go ahead and skip a little bit of irrelevant points he's just kind of reiterating. And again, consent does take care of a lot of things, and not having consent can. And if you agree that the legislature has jurisdiction, you're raising a merit issue, and jurisdiction's kind of off the table. It's there to be decided, and it'll be part of the trial and decision-making process. So let's go ahead and skip the irrelevant part a little bit here. Well, buggy whips. All right.
necessary for the other two. Now, you should also know that there's other situations where the court can have limited jurisdiction over you. And for instance, the existence of any of the following relationships between an individual or his agent and the state shall constitute a sufficient basis of jurisdiction to enable a court of record of this state to exercise limited personal jurisdiction over the individual and to enable the court to render personal judgments against the individual or his representative arising out of an act which creates any of the following relationships. One, the transaction of any business within the state. So you can be domiciled in Ohio, never set foot in Michigan, but if you transact business in Michigan somehow, I can get you served and I can get you summoned into a Michigan courtroom.
That's scary.
Well, I mean, you're presuming, of course, that, again, legislature, if the legislatural jurisdiction is presumed, he's fully on. If he can prove that the legislature has jurisdiction, I have to agree with him.
Good luck.
But then again, I wouldn't give him a freebie in court. I wouldn't give someone making this assertion that freebie in court. I wouldn't want to inconvenience him with providing evidence of his assertions, right? A few more seconds here.
And if you don't show up, we'll default you. The doing or causing an act to be done or consequences to occur in the state resulting in an action for tort. So you did something or you caused something to happen in Michigan, even if you weren't here. If a tort arose.
All right. So if a tort actually arose, so meaning not the accusation of a tort, mind you, if a tort occurred, then there's some jurisdiction that can be had. I mean, I'd contend that there's a little bit more to it. For example, that the victim passed that jurisdiction on to the person making the accusation.
The prosecutor's office?
Yeah. But so someone's actually harmed, and the court's actually seeking ethical justice, and if challenged, they just provide that evidence of that, and boom, my objections are all satisfied. Easy.
I can sue you for that and get good jurisdiction over you. The ownership, use, or possession of real or tangible personal property situated within the state. So you own property here. It's not your domicile. It didn't arise to any tort or anything, but you have property here. That can also get you limited jurisdiction over you.
Limited by what they want. This phrase about get you jurisdiction in actual reality means you get the cops on your side to do violence.
Right.
But that's what it means. Oh, the cops are going to be in my back pocket and do my will. I've got jurisdiction.
Right. So he's talking about convincing a court to take up an issue, not at all talking about the issue of the court having a right, but rather court being inspired to. There's very different things. It's like procedurally a court jumps into an issue versus having the right ethically or justification. Just being justified by facts rather than just by fiat, by the decrees of the legislature, which is what we're talking about. Sounds awful sovereign-ish to many people. The difference is always about a Socratic approach versus an assertion. The Socratic approach is a very, very old issue about justice. It's something that's been the war between power and justice for a long time, and it's one that really needs to be woken up a bit again. Is that and we're being relegated. It's like, well, any time you're fighting power with the idea of justice, you must just be making an assertion of some other concept of power, and you must just be the opposition and wanting some other power structure, and we're just as good as that and better, and and it's funny. I mean, they're even trained to be extra brutal to sovereign citizens.
Oh yeah. I mean, during a recent stop, they asked me, "Are you a sovereign citizen?" It's part of their training because they've got a whole training
Yeah.
path to go down. A cop on the side of the road, if you claim it.
And it's almost like, in the in ancient times, what would you said? It's like, are you, a member of the Church of England? It's like, that's not a good question to be asked. It's like, I was like, does that mean extra brutality is due?
And you talk about brutality. If you're listening to this video and you're interested in learning about jurisdiction, I mean, you probably already know this, but I'll just bring it to the forefront now. This is quite commonly not just speeding tickets on the side of the road or some civil lawsuit. This is how parents lose their kids. I mean, to me, that's probably, other than sending someone innocent to lengthy prison term, that's the most damaging thing these courts do, is get interfered with divorce and child custody cases. And so this jurisdictional issue, every bit as applicable from top to bottom of the whole system. That's why we're obviously taking the time to flesh it out and make this new channels, because these issues are really of utmost importance, and men need to be educated about this stuff if you're not.
Family courts are extra brutal, and it's a sad situation. It's one where justice is even more important, but less available.
Because the best interest of your child will never be the focus of any procedure in that building. Anyway, not to sidetrack, but
So I'm not going to go through all of these, but the point is that there's a bunch of different ways for the court to get jurisdiction over you, and these are all defined by statute. They're all defined by law. And again, there's people out there who go, Steve, codes, statutes, regulations, and the law are 4 different things, when in reality they're all synonyms. They're all the same. Statute is...
And legalese is a very precise language.
Yeah.
And that concept doesn't hold any water.
So, that erases a huge body of philosophy and of jurisprudence. There's phrases for the thing he just got rid of. It's called malum in se, and pre-political rights, sometimes called natural law. That causes some confusion because people think it means physics. But he just waved away the whole concept of wrong for the sake of being wrong, and wrong because it's forbidden by legislature. And it's an important conversation to most people, and even some lawyers might even find it important. Although I'd like to find more lawyers that actually did understand that difference and care about that difference. But to attorneys, these are essentially the same, and to the accused, they can be a world of difference and an important difference. Substantive justice versus procedural justice comes into play. Substantive rights versus procedural rights comes into play. And how these get balanced and which one takes precedence comes into play. And the fact that he just waved those up, and to a lawyer, it's you don't care. You just find an argument to make and hope a judge goes your way. Right and wrong, you get paid pretty much the same. You just come up with an argument. And any substantive right that gets in the way of a procedure, waive the right is almost universally what you'll see.
Trial. You don't need that. You don't need right to counsel. You can represent yourself, but we're warning you that's not smart.
Well, most lawyers will waive your rights to speedy trial, waive your rights to be informed.
Yeah.
They don't care if you're in the dark. They're not. They know all the procedures they're intending to use, and even if they don't want to inconvenience a judge and anger a judge in order to get that information.
Right.
But it's...
You know what? Go ahead.
It's basically the difference between ethical and unethical. He just waved away. Did we do it by the book, or did we do it by justice? And he's the difference between by the book and by justice is what he just equated. He just waved one away by caring only about procedure.
There's for those people who may be listening who are not in agreement with what we're saying, I just want to point to one video real quick. If you go onto YouTube and type in Joe Rogan Experience Lawyer, I can't remember this guy's name. I'll put the link in the description if I remember, but he does an interview with a guy who is now a current comedian who used to be a public defender. So he gives 0 Fs about telling it like it was. And just listen to that video. He actually worked in Minnesota or Michigan, if I remember right, same as this guy. Listen to that video, extremely revealing, eye-opening, and it'll just let you know someone who was on their team just saying how it's corrupt in a million different ways from Sunday. So I would just offer that up.
Is a law, a regulation is a law, a code is a law, and so on and so forth. So the fact that these are statutes or these are laws, doesn't matter what you call them. For those of you who want to complain about this, first of all, you're making a distinction that doesn't actually exist. But number two, the books that I pulled these out of are called Michigan Compiled Laws, MCL. So the fact that I refer to it as legislation, well, it was legislation, and when it got passed, it became the law. So these are laws. But courts can get jurisdiction over people a variety of ways, and then get jurisdiction over corporations in a variety of ways. So in the example of somebody who's in the state of Michigan who gets served with a summons and a complaint, jurisdiction over you is now good. If you are here, your presence in the state will create the jurisdiction for you to be, hauled into court.
All right.
Why will not a judge, and I've personally heard dozens and dozens of judges being given this opportunity in court, why do they not reference this? The codes and statutes are applicable because, according to this that was written down, as Steve is saying there, the legislation. Dozens and dozens and dozens of opportunities. Not one of them ever had anything more than just an opinion.
Okay, I mean, they've... Like I've heard, okay, in some sense, I've heard them allude to it or just direct to the fact that it was written down. Like to say, when you ask about the applicability, they'd say, well, are you asking about it being written down that way? And I don't know, feign some kind of confusion about it.
I'm just asking for, if what you're saying is true, where do you get that from? It's. I assume you believe it's more than just your opinion, correct? So where are you getting this information from?
But most codes have written down in them that they apply.
And then you go back to where we always were. Just submitting that answer, like all other answers, through logical fallacy filter. Number one.
Yeah.
Is the Bible true because the Bible says it's true? I mean, the military does it this way. They require a signature. You don't. Why is that? Where, you don't even address it. Again, I've asked for this. I've volunteered to plead guilty, pay the fine, and be out of your hair. If you show me a copy of the last piece of information I need, whatever was provided regarding the element of jurisdiction.
Well,
not a single.
And well, I mean, one more. They wouldn't even admit that none had been provided.
Yeah.
So they wouldn't even tell you whether or not there was anything provided because they didn't want to confess that nothing had been provided on this because they didn't want to open up the argument.
Because I've gotten them to previously admit that, yes, in fact, I was presumed innocent of this element of jurisdiction. And yet no guilt, no evidence of any kind has even passed.
So, I'm sorry. So, just to be clear, a court had informed you that you were presumed innocent of jurisdiction until or unless it had been proven that there was jurisdiction. And they didn't just offer up your location as the proof?
Oh, they might have. I can't remember this specifically. I mean, you get so many deflections thrown your way. That very well could have been one of them. Mm-hmm. Oh, well, you were in city of blank, weren't you? Okay, so all I'm looking for is just a reference to where you're getting the information from that says these statutes, roughly, these statutes or codes are applicable because of reason X. Because of reason I'm within your borders. Is that the claim. But further, right now, if I was doing this with a judge, I'm into a trying to determine process, which is a place I don't need to be. I just ideally would stay at, has any evidence passed between the prosecution to the court, not to establish, just regarding this element of jurisdiction you admit I'm presumed innocent of.
So the whole point that Lehto here made about, well, if the location is blah blah blah, then they're good. You kind of blew that away, or that judge wasn't aware of it, perhaps. Sorry,
All
I can't
right.
complete that. But in a formal setting, the judge didn't go down that road,
No.
or the prosecutor, or whoever.
Those that try, when they get embarrassed, because the Socratic method of investigation is so powerful when used in conjunction with logical fallacies and ethics. They get so embarrassed.
Stopping logical fallacies.
Yeah, right. They get so embarrassed that they quickly learn, oh, I better stop slinging BS in his direction because it just comes flying back at me twice as stinky. And then they'll resort to violence, or they'll straight up run off the bench, close the case, you don't get a chance to respond, and they leave when they hadn't planned to.
Yeah.
I've seen all the above happen multiple times.
Right.
That's telling. That is so telling. He has all the power in the world up there.
Yeah.
Bailiffs won't question, hey, take him into custody, contempt of court. Who knows when you're getting out? He's got all the power in the world, and they're running. This is what we're talking about. This is, learning about how that works and how to do it, if wanted.
The question then becomes, does the court have jurisdiction to hear your case? Now, it's not saying does any court have the jurisdiction, but does this court have jurisdiction? So in the example I gave where I said, I live in this county and you live in Lenawee County, and you bought a car from me and it was stolen, and you want to sue me. If you sued me in Sanilac County, okay, I would bring a motion to dismiss the case and say, well, this is the improper forum for this. The interesting thing is that the courts could get jurisdiction over me if I consented. But the court is most likely going to look at it and go, why'd you file that here? The court that appears to have jurisdiction over this would appear to be the court in the county where Mr. Lehto resides. I've seen people file the actions where they live because it'd be more easy, more convenient for them. And here's the thing. Once in a while, there'll be separate courts that each could hear something, meaning that each of them has jurisdiction. But then there's a question of venue. And venue is if there's more than one correct jurisdiction, then which one is better? And sometimes I've seen it before where the statute, for instance, on corporations says a corporation can be sued where their resident agent is, or where they transact business, or where the cause of action arose. And so you'll have a corporation that's got a registered agent in Lansing with one of the companies that's just a professional resident agent for people. And then the transaction arises in Wayne County because that's where the product got sold or serviced or something. And so you have a question, do we file this in Wayne County or do we file it up in the court near Lansing? Because that's where they're located, but the cause of action arose down here. Both of those courts might have jurisdiction, but the proper venue is going to be possibly down where the transaction occurred, because that's where most of the witnesses are. But we'll often get in fights over that, and there'll be a motion or change of venue, and that's another story altogether. Today, I'm simply talking about whether the court has the right to rule over you and the claims against you. So,
The right.
Yeah.
The rightful justification.
Suddenly he remembered an interesting word there, didn't he? So territorial or venue bickering is just a strategic issue for people arguing merits. I mean, it's like whether or not the right to impose is pre-political. It's a substantive issue. There are procedural pieces that can get rid of, that right according to, statute or law. But he keeps removing and reintroducing the word right. And, if right doesn't have something to do with wrongful, if it's just some word that's a placeholder for power, then it's just devolved into meaninglessness. It's right is a shorthand for doing something that isn't wrongful to do. And granted, there are political rights that are just privileges, and I get that that's probably where his mind is in thinking about rights, is just what privileges the legislatures and courts and so forth, the structure has for him and his. But there is a when we use the word right, we usually mean rightful. It's a shorthand for something being rightful, a rightful choice to do, a rightful action, a not wrongful action, an action that doesn't violate ethics, probably a Kantian type ethics, even if we're in the U.S. But it's just telling that he's using and not using that language back and forth.
Yeah, like it's sketchy. I don't want to open this can of worms, but I mean, super short example. So after dealing with some courts over nonviolent victimless criminal charges that eventually were dismissed, I just went down the Bill of Rights and was like, which of these do I actually have? Which hasn't been broken? And the only one was, I think the third, the quartering of soldiers in my house. Everything else, the police or lawyers or courts had violated. So I don't believe in rights. I translate it into the language that is implied through the meaning and the context. So yeah, rightful justification is, do judges have rightful justifications to impose?
Yeah.
When you're driving down the road in any state in America, driving down the road, public roadway, in an automobile, and a police officer pulls you over using his overhead emergency lights, which he has the right to do, despite the fact there's no emergency, pulls you over, walks up to your car, says, do you know I pulled you over? And you say, of course not, I have no idea, no clue. I've done a video on this too, so I'm joking. And he says, well, I clocked you doing 75 in a 55, 20 over. That is a violation of the law. May I see your driver's license and registration? And the police officer then proceeds to write you a ticket for speeding. And he hands you the ticket and says, see you in court. And you decide to fight the ticket. And you go to court, and you walk into the court, and you go, Your Honor, this court has no jurisdiction over me. Well,
Okay, you decide to fight the ticket. That's I don't even know how to address that, straw man, but you decide, I guess this hypothetical person decided to inform the court of how the court was going to be. Again, sovereign straw man garbage, but
They have the guns. So you don't understand this? Like, oh, you don't have jurisdiction. Okay. Assume that burden of proof. Boy, make that argument to a lawyer. Woo, that's...
again, what maybe should be decided is decide to challenge jurisdiction rather than to denounce, assert the opposite, assert that you don't. I can prove that you have no jurisdiction, and they'll be like, all right, you get 3 seconds.
Every single time I ever asked a Socratic question in court, it wasn't because I didn't know the answer. It was because I did know the answer, but I needed it to come out through their words, not mine. Their answers of their actions. The burden stays on them.
I've certainly been surprised by what they've said, but I didn't. Knowing the answer and knowing what they're going to come up with are two different things, though.
Yeah, like I know that they haven't provided jurisdiction, but do I say, you haven't provided jurisdiction? Absolutely not. I asked them if they've provided it. So what's that saying? Never ask a question in court you don't already know the answer to. It's like some lawyer advice or something.
Yeah, ideally you would also know how they're going to answer. But, well, when we're trying to get informed, they can come up with a lot of interesting things. Let's try to make it a little further down this road.
They do have jurisdiction over you if the traffic infraction occurred in the jurisdictional region of that court. So, for instance, in Oakland County, there's a circuit court, but each of the local municipalities has its own court. So, like for instance, there's a court in Clarkston, Michigan. So, if you were speeding nearby Clarkston, like within Clarkston, and a Clarkston police officer wrote you a ticket, and you go into Clarkston Court and stand in front of a judge and say, Your Honor, you have no jurisdiction over me. Judge will say, well, look at the ticket. It says here that the infraction occurred in Clarkston. And that's jurisdiction. You were within the jurisdictional area of this court.
All right. So so he just presumed, in acting, this hypothetical judge, that an infraction occurred just because it was asserted that it had.
Yeah.
So, and I've seen this actually. I mean, judges do this routinely. And it's like, well, we have jurisdiction. They never say the word if. They said because this infraction occurred here. Now, it's like, where the hell did you come up with that? Did I admit that it occurred and that it occurred here? I mean, is there no burden of proof on this issue?
Because it works with virtually 100% of people that he's ever going to have in front of him. It just works. People know they were speeding maybe, or that they were at this location. They don't know how to challenge. They don't even know to challenge. And they just get convinced by this and kind of go along with it. That's a nice tactic. Like, so much easier to impose upon someone if you can get them to kind of go along with you in this bullshit dance.
But at the same time, you'll see people saying allegedly and insisting upon that in other similar situations. It's like, wait a minute, it's alleged to have occurred.
Yeah.
So if something's alleged to have occurred, does that change the jurisdictional nature? It's like, well, does jurisdiction change based upon facts or change based upon speculation?
Huh.
And it comes to that same thing, and he just walked right over that. And he did so in the same way that judges often do. An essential element of the assertion was just presumed before you even made it into arraignment. And now it's like, wait a minute, you just basically said you're accepting that this infraction occurred. We're done. How am I going to get a fair trial when you've already that prejudiced? You've revealed that you've already decided.
All right.
Just based upon the accusation itself. Now, does the presumption of innocence go all the way to that accusation, that a violation occurred, making this a threshold issue, or not? So either the presumption of innocence includes this factor, and a lot of judges will try to argue that it doesn't in certain settings, but then when pressed, really kind of fold up and have difficulty with it. But it's a threshold issue unless, if you object, if you make it a threshold issue, if you agree that the violation occurred and want to argue some other point, hey, maybe you have that, maybe you want to do that. But challenging jurisdiction is a threshold issue. Counter-asserting that there isn't jurisdiction is kind of more of a trial or hearing issue, I guess you'd say. And I don't even know how you'd kind of go about that. Well, I know how some people have gone about that, especially in instances of like sovereign immunity kind of thing, where people kind of get rid of something because of power. But a challenge to jurisdiction would be at arraignment or before. This whole jump into trial idea that he keeps bringing up. It's like, well, fast forward into, getting out the crystal ball and seeing how a trial would go and then bringing that information back to the, there's a whole foundation, there's a whole structure to like logical arguments where you lay foundation. But then again, if you don't care about them structuring things properly, if you don't care about your opponent, forcing your opponent to do foundation and then point upon that foundation and then point upon that, he won't. And judges probably won't on this topic.
Right. And we see these lawyers jump from arraignment to trial all the time. And what was the most critical step that he just hurdled was a plea was entered. You can't get to trial unless a plea is entered, and it's impossible to enter a plea without admitting that these people have jurisdiction.
Okay. I mean, I know your point there, but just judging by someone who might have been hearing that for the first time, it happens all the time that a trial happens without a plea entered.
You mean forced on the
Well, a plea entered by
your
the
behalf?
accused. Well, a plea can be entered by on your behalf. Yeah.
Yeah.
Yeah. So it happens all the time that judges will enter pleas on behalf of people who are refusing to plea or pleading in a manner that isn't.
Declining.
Well, the words used is a refusal.
Yeah. Good reason.
But again, we're talking about the instance where someone is trying to be informed in order to plead, or trying to be informed to make an informed and knowing plea on a topic that you have the right to be informed on, but they don't want to inform you on. That really comes as a major issue. Is if you're wanting information they don't want you to have on a topic that you have the right, so-called, to be informed on, it becomes a real catch for them. And what they'll do is they'll enter a plea on your behalf, and sometimes even over your objection.
On the prosecution's behalf.
On the prosecution's behalf, yeah. On your behalf would be if it benefited you. So it's certainly something that benefits the opposition.
They don't allow you to plead innocent. Whatever happened to that? We won't open that can. That's another can, but yeah.
All right. So, right. So let's go ahead.
And I've seen people say, prove to me you have jurisdiction. Well, when the officer gets on the stand and says, yes, I pulled this person over and pulled them over in Clarkston,
There it is.
that's jurisdiction. Now, if you want to, you can say, prove it. I wasn't in Clarkston. Okay.
That's not at all what we do.
If you want to do that, I guess
You just
God
lost
God
the
help
crowd.
you.
You just lost all public and political pressure.
And that is probably why sovereign citizens have such a reputation.
Yeah.
But challenging location is just dumb. It's dumb even as a straw man. And it's a trial issue. If you're saying I wasn't located there, that's a mitigating, that you're in trial. I mean, you're bringing up a merit issue, not a jurisdiction issue.
Yeah. You're basically calling the cop a liar, and what percentage of the time would a cop lie in that circumstance? This better not be the first time. If that in fact happened, like if by some miracle some cop says you were here on Thursday and you were nowhere near that place, that shouldn't be the first time this is brought up. That would be brought up right from the jump to have any kind of believability whatsoever, even as unlikely as
Yeah,
that is.
I mean, you should be asking clarifying questions that point out the stupidity of it, and
Yeah. Where's the cop camera? Where's the dispatch schedule?
Sometimes.
Anything that they have to support their claim that you were somewhere you weren't. But anyway, yeah, don't do challenge location. Challenge their use of a logical fallacy to apply location to the applicability of the statutes and codes.
I mean, that's exactly the argument they want.
Yeah.
They want the argument to be, well, we have jurisdiction if you were located here, thus the argument is about the location.
Right.
And it's like, no, the argument is about your assertion and this non sequitur where you're saying, if you're located here, then we have jurisdiction. It's like, well, can you prove that to be true without reaching to an assumption, without an assertion that we have jurisdiction if location, because legislature said so. And it's like, okay, now we've got an additional element. The legislature must their decrees must be applicable in order for you to be correct. Do you have proof of that?
Right.
And I mean, again, the judge will probably chime in and says, I'm not going to make him prove that. I was like, okay, so you agree that there's a non sequitur in the middle of his assertion. Yeah, in his case has a non sequitur in it. That is a failure to state a case.
Yeah, and that's one thing I didn't like about Steve's video was he portrays anyone who opposes his video and definitions of jurisdiction as people who are not being convincing or competent or asking the right questions at all. I don't know if he's even aware of people who go in and challenge jurisdiction via Socrates instead of some Sobsit clone way. But see, the difference is he has to lower any opposition's image and capabilities in order to defend against it. Whereas we could glorify any lawyer on the planet. We could glorify them, steel man their arguments, make them as intelligent, as crafty as humanly possible, and still smash their claims and assertions about any competing issue to logic and ethics in a very convincing way to however many third-party objective fence sitters you want to hypothetically imagine up. We would smash them. They cannot steel man our position. They can't even come close to responding with any semblance of logic or ethics to steel manning our position. It's low-hanging fruit. It's a low quality.
And I do sometimes sympathize with the goal of legislatures and of lawyers. I sometimes sympathize with their goals. I just don't sympathize with the misdirection and with the lies that they have to put into the middle of things. And one of them is that an innocent person who's accused of a crime is presumed innocent. That's a lie. That's a lie. He's not presumed innocent. He is either presumed guilty or he's presumed to be cooperating. Those are one of those two has to be. And the innocent person who is unwilling to go through trial, try to get a lawyer to talk about that. Try to get a lawyer to talk about that hypothetical person, an innocent person who's not willing to be tried. Is it right or wrong to put him through arraignment?
And keep in mind, lawyers cannot bring up this challenge to jurisdiction or they'll be disbarred. We've
It's
had
happened.
several lawyers tell us they could not take our case because they were too afraid for their license. They wouldn't be able to say these things. They just can't. So that's just FYI. The system is set up the way that the lawyers can't say the words we're saying to you right now in this video.
Yeah. And they can challenge jurisdiction only in a procedural manner because they're political, because they're there to represent political process and procedure and represent political rights. And the idea of addressing pre-political or natural law or anything like that inside of a setting, inside of a procedure, is just foreign to them and sacrilege.
They are just engaged in sales. Being a lawyer, whether you're a prosecutor or a criminal defense lawyer, you are a salesman first and foremost.
Yeah.
100%. Like an arguer second.
Presume applicability. It's what your life is depending on.
Well, at that point, it's your word against the officers, unless, of course, the officer might have, camera footage of you being pulled over. You might be able to identify where it is by the video. But the point is that I've seen people saying, yeah, but show me proof that jurisdiction applies to me. No, that's not how it works. There's a law. It's on the books. It's words on paper. Now, but that's all any laws are. So to go into court and say, I need to see proof of the jurisdiction is the same as saying, I need to see proof of the Constitution, or I need to see proof of the First Amendment, or I need to see proof of the Second Amendment. The Constitution is just words on paper also. That's all.
So we died laughing the first time we listened to this.
He has just conceded this point. Jurisdiction, as he's conceptualized it, is arbitrary.
Just words on paper.
Just words on paper. Just an assertion. Now, it has to be given in order for that to be true, or in order for a court to proceed, in the face of a challenge. They need it to be given. They need jurisdiction, the issue of the applicability of those laws and those words on paper. He needs it to be given. It can't be proven. All he has to do in a court setting is admit, all we want is for them to admit that it's not an issue that can be proven or that they intend to prove, and that they have no evidence that these codes are applicable. Hey, then we can address that point. Take a moment and address that point. They know better.
Yeah.
Very,
Because-
very few have made that mistake.
You know what would come up right after that? The violence.
Right.
Oh, the violence starts getting exposed really quickly when
Yeah.
they have jurisdiction, but they need not provide any evidence
Yeah. And
of it.
we've all motioned to dismiss for failure to state a case on that point. We've seen it done many times. It's the way to go. It's generally the way to go. And it brings that whole issue up to be decided logically rather than just like he's saying now, it's a given. The prosecutor gets it because he gets it. He needs it. I agree that he needs it. He needs it as a given. He doesn't have proof. And if he admits he doesn't have proof, he has an issue on his plate that he doesn't know what to do about.
Yeah, I mean, this is 5% of the world's population does America have, and we have 25% of the world's prison population. And these guys are working for, 35 cents an hour.
Mm-hmm.
I mean, there's big time profit and power that is fed through this design. And if you live in America, this is your country. This is the country you live in. Only a slight deal.
Yeah.
Laws are. Unless you want to go back to Code of Hammurabi, in which case I think they were words carved into clay tablets. Cuneiform on stone. But the point is, it's all any law is. And so if you want to get into this surrealist, reductionist thing existentially about whether or not laws exist, you can make the argument, but you're going to lose it every time. Because the way you prove jurisdiction is you simply prove that the facts that create jurisdiction existed.
And there we are. What would that look like? The facts that create jurisdiction existed. But that he just got done saying it was a political issue, that it was an issue of pure law, so to speak. That it is just an assertion that is a given that has no reference to reality, has no need to concern itself with the reality. Because, whatever, tablets or whatever. Because you, God forbid you reduce it to absurdity, it is absurd.
Ugh.
The idea that someone writes something down and it's applicable because it says so is absurd.
I think
So,
go ahead.
So what would it look like to prove it? They see some notion that it needs to be proven. Well, why are they recognizing that it needs to be proven and then not recognizing that it needs to be proven?
Yeah, that's what I was going to point to, is a contradiction. It's like, all this says is words on paper, words on paper. Okay, but you're imposing an entire justice system upon potentially innocent people, especially with your nonviolent victimless criminal charges, over these words on paper that don't really mean anything. So how are they given meaning? Now, he doesn't have anything to say about applying facts to establish something of such critical importance. But as soon as he gets to, how is jurisdiction determined where he is on safe, firm footing again? You bring up the facts. So he has a huge value for facts in one sentence, but not in the other. And he's combining the two in an odd way. I'm just like, all right, so you want to give meaning to words on paper. How do you do that? Okay, I agree. Facts are important.
Yeah.
So, and again, this isn't a problem that the military has. This isn't some abstract, surreal, existential angst, whatever you brought up. There are measurable things called facts. We can show them to everybody, and it's kind of self-evident whether or not they're true. And we value that process because that's how truth is arrived at. And you're depending on truth when you try and create this thing called a justice system. Like, you just, from the jump, you're screwed. But then he landed. He jumped out of an airplane without a parachute, but landed safe and sound. Facts are important here, they're not important there. It was funny. Wow.
So when the police officer gets on the stand and says, yes, I was driving up Dixie Highway within the city limits of Clarkston. I observed the vehicle speeding. I turned on my overheads, pulled the person over, wrote them a ticket, handed them the ticket, and that's the person I see sitting right there. The judge is going to ask, did that happen in Clarkston? Yeah, it did happen in Clarkston. Okay, jurisdiction, bang. Now, where's the proof of jurisdiction? Well, the officer testified. His testimony is evidence, and if the judge finds it more likely than not that he's telling the truth because there's a preponderance standard and
This is hilarious.
There is not a preponderance standard in jurisdiction itself, even if the decision itself is preponderance. Jurisdiction is a threshold issue that has to be proven, not it isn't a favor the judge can give.
Right. I think he was trying to sell the illusion that when weighing a cop's testimony there's some measurable standard a judge is using in his head when we all know that's complete
Yeah.
horseshit. He's just going to believe the cop every single time over Joe Q, ticket getter.
Right.
So it's just, again, salesmanship.
So, again, and he certainly, the location wasn't at issue for a sensible adversary. It's a non sequitur that location proves jurisdiction. He just keeps reaching to that. Like his burden is only proving location, and it's common. It's real common for prosecutors. It's real common for
The
lawyers.
most common.
Is in certain settings they've done. It's like, okay, satisfy the non sequitur or agree that there is one there. And you'll have judges trained on the issue of what a non sequitur is suddenly forget what a non sequitur is. It's like, well, I don't see the disconnect between location and jurisdiction. It's like, well, then you're an idiot. But I know you're not, so you're lying.
Oh, yeah. Playing dumb. They quite commonly will play dumb.
Yeah.
They'll just answer really poignant, relevant clarification with, well, I'm not sure what you mean. Can you move on?
Yeah, I'm not sure what you mean. Can you move on?
Speaking English.
I've had a judge, a female woman of color judge, tell me she didn't know what the word prejudice means.
That's right.
It's yeah, and it's like, all right, well, that's the game they play.
Yeah.
There is no honesty has no place in a courtroom. I guess is what we're up to.
Implied threats and pretty transcripts.
In civil actions such as the civil infraction tickets, then that's the proof. That's the proof. And like I said, I've seen this argument raised many times, and people say that they go, well, what's the proof? What's the proof of jurisdiction? What's the proof of anything? What's the proof of speed limits? What's the proof of murder being a crime? The proof of the laws is that they are in print someplace, but they were adopted by the legislatures of the various states, and these laws exist, and we've all agreed as a society to follow them.
We've all We've all agreed.
We all
We've
agreed.
all agreed. I mean, I can't believe that's coming out of a lawyer's face after 27 years. You
This
never
is-
say all.
This is clearly a delusion. It's in print someplace, and we all agreed. Okay, so if anyone didn't agree, their whole system's bunk, right? I mean, I think I can agree that given that premise, he's right, and I hope he'd agree that if I take away that premise, he's full of crap.
Yeah.
So, well, there we are.
I mean, maybe, I'll give the guy a break and say, hey, he just misspoke. Sometimes, you put on a 17-minute video, you'll misspeak a time or two. Maybe even if he said most, that doesn't make it any better.
Well, I think maybe the accused all agreed. Maybe he's never seen an accused who didn't agree. And you know what? He might be right. That's really uncommon. Challenging jurisdiction is super uncommon.
Ridiculously uncommon. I can only imagine how uncommon.
Because it takes a lot of study to be able to contend with the amount of crap that the judge and prosecutor and any lawyer who's assigned or any lawyer who's involved is going to throw at you. You have to be able to contend with it. It's a lot of work, and it's a lot of brain power needed to kind of navigate that. It's really, you got to understand Socratics to some level. You have to understand some procedural garbage they're pulling out, and understand the difference between procedural and substantive issues and procedural and substantive justice. Yeah. But this delusion, I mean, we all agreed. Well, fair enough. If we all agreed, I can vouch that I didn't. Minus one.
There's one thing I want to touch on here really quickly too that we've talked about a lot, but we haven't really addressed it. And I just want to take just a brief moments to go into it. So the legislature power that he reaches back to that we've mentioned a few times. So this is gonna be super quick. So I've had judges tell me this, lawyers tell me this. Oh, if you don't like it, you can have the laws changed. You can vote. You can get involved in the political process. This, that, and the other. Okay, so Keep in mind, a lot of these ordinances are written by, council members, like county council members, city council members. Then, of course, you've got your state government that makes state laws and your feds, right? Okay, so all the elections that happen for all these people, of all the adults and children, let's face it, but of all the vote ageable adults, what percentage of them actually vote for the candidate who won? I mean, for sure, 50% of the population doesn't vote. So right off the bat, see, if to vote for no one could become president, that no one would be president every single time. So you're already, it's a rule of the majority. No, it's a tyranny of the minority. So you've got, let's get generous and say 30% of all adults in a county vote for leadership. Now, maybe 20% of those voted for the winner. So right off, these are very generous numbers. You've got 1 in 5 adults actually was silly enough to go vote to have this master over them making rules that they have to obey by. Otherwise, it's the police getting in your face time. 1 in 5. And yet they presume to, they rule over everybody. So even if they had, legislative, even if if they could reach back to legislative dealings to be correct, it wouldn't be correct because far from all of us have agreed. Maybe at best 20% have actually voted for the winner. You want to put those 20% under your statutes and codes? Great, go ahead, do it. But the other 4 out of 5, you're just imposing upon while providing zero evidence of the rightful justification or jurisdictional evidence to do so. So that answers the legislative part. Just wanted to get it out.
Right. All right, let's get through a few more.
You don't follow them, certain things will happen to you. And if you choose to believe the law doesn't apply to you, that's a decision I guess you can make, but you have to live with the ramifications, which is going to be that you wind up in court an awful lot going, prove to me that jurisdiction is real.
No, you don't.
And the judge is going to go, it's a law like any other law. Do you have anything further to object to, or are we done here? So that's...
You don't, low-hanging fruit. You can't steel man the opposition. You have to turn him into a dummy.
Yep. It is unwise to do what this hypothetical straw man he's constructed is doing.
So
Counter assertion is not too good. Challenge is a whole different ballgame and something that can also be dangerous. That also needs some care and preparation and education.
Never mind, if you ask for proof, you're basically asking for a trial because evidence isn't determined into proof except at trial. And to get to a trial, of course, a plea has to be entered, and in order to enter a plea, you have to submit to the jurisdiction.
You're already basically waiving all your issues to get to the point of arguing about issues.
Right. And then when you get there and you challenge jurisdiction at trial, they're just going to find some real convenient reason to sweep that away. And, here we go. Be quiet. It's not your turn. Prosecution, you're up first. Mm-hmm. What's going on?
We've seen people actually be lectured that jurisdiction is a trial issue at pretrial or arraignment, and listen to that hogwash, and then try to bring it up in trial and be told that it was a pretrial issue and they're too late.
Yeah. Yep.
Well, just a few more seconds here. I think he just wraps it up.
Jurisdictions. Remember, it's basically two things. One is what types of cases can a particular court hear is a kind of jurisdiction, and then, of course, when do they have jurisdiction over you? That is, and so the proper jurisdiction means they've served you properly, brought you before the court, and they brought you into the correct court to hear your case. That is jurisdiction. Questions or comments, fire them below. Talk to you later. Bye-bye.
That is procedural due process, not substantive.
But what he says is great for billable hours. Great. Let's get the highest priced lawyer we can afford and make this last a long time.
All right, let's have a quick look through some notes, see that we've covered everything here. All right, any reason impending jurisdiction means there is not jurisdiction. Okay, so that's basically just recapping that jurisdiction means that there's no flaws in the assertion of jurisdiction. It's not meaning that there's all it takes is having a reason to assert and you're good. It's meaning that there is nothing in the way. There is no wrongness about asserting jurisdiction. It's opposite views of jurisdiction. And one is ethical and the other one is not.
Well,
All right. UCMJ and contracts stipulate jurisdiction. Easy to kind of satisfy on that front. Threats of violence eviscerate notions of contract. That's where a lot of people come in thinking that everything's a contract, and ignore the violence involved in that. When they say, "Oh, well, it's all contracts," it's like, well, that's hogwash. If there's a threat of violence involved, your thinking is going to be hugely wrong.
see, and sorry, it reminded me of something like, why do so many people delude themselves into ignoring the violence that's involved? I think, several reasons, but to me, one of the most likely is that if there is violence involved and a man really has to face that fact, then he has to also face in the mirror, admit that he is being coerced by these bullies who are willing to use violence against him. And that is not a fun feeling.
No.
That is not good to be like, hey, in life, I don't have what it takes to defend myself from people who threaten me with threats of violence. So they don't want that, again, wolf to be among the sheep. They're just, oh no, this is voluntary.
Well,
I'm not a coward.
I mean, the alternative is to educate yourself and to prepare yourself, and to gain the tools you need to deal with these people. I mean, that's what that's the road I headed down. Is that fear sparked an obsession to get my head around it.
Yeah, I mean, knowledge is power. Like a live streaming camera is more powerful than a gun these days when it comes to preventing the police from getting crazy out on the street.
Sometimes.
So,
The right to be informed is super valuable to accused people and super inconvenient for prosecutors. It is the hinge point. The fairy tale is that arraignment is when they read off the charges from a piece of paper,
scare you with max penalties.
Yeah. Ask you how you plead, and all they want is one of a couple words. They don't want any questions. They don't want you to clarify squat.
Right.
They don't want to inform you beyond what was just read out. And you have the right. You have the right to be informed, or you don't. If they tell you have the right, and then they don't deliver, well, that's a little bit of a contradiction there that you can contend with.
Yeah. And this is all relatively easily digested by the people watching, which gives it power.
Yeah, if you ask them, do I have the right to be informed?
That's straight
and
up
they
out
say
of the Bill
yes.
of Rights.
Yeah.
God's sake.
Yeah. And then they say yes, but you ask a simple question about what you're accused of, and I don't know what the prosecutor maybe handed the judge. If he handed something at all on a topic, yes or no question, and they flip their lid, the people behind you know that there's something up.
That's directly the cause of the charge.
Right.
What did the prosecutor give the court to cause these charges? You just said I have a right to be informed of it. It says in the Bill of Rights, but you're threatening me with jail if I don't stop asking that one relevant issue.
So in context of this video here, what evidence is there that the codes or statutes or whatever apply to me? What piece of evidence, or has any piece of evidence been handed to the court, given to the court by the prosecutor? It's a yes or no question.
That's simple.
And they throw a fit rather than say no.
Because you're pulling back the curtain.
All right.
And all these people around here are seeing exactly what's going on. And it's all the gun. There's no consent of the governed.
And
it's a disgusting phrase anyway.
And, all of this video from Lehto, indicating that it's satisfied, they don't need any. Boy, you get into court and you get into an arraignment question about that, and they change their tune. Suddenly then, it's not, we have none because it's not needed. It's make the question go away instead.
Yep. Silence. Free speech, my ass.
All right. Failure to provide due process is commonly known and openly discussed, but not commonly corrected. So we have all these issues, like one of them is Brady materials. Like the Supreme Court will talk about it's rampant violation that the prosecutors aren't providing requested Brady materials that the defendants and that the defense has a right to have, but they're not doing anything other than saying that's bad.
Yeah.
They're continuing with this injustice. They're continuing, especially on Brady, where where when the question comes up, they'll say, "Yep, that's absolutely something that should be given to them," and nope, we're not doing it. But to hell with them anyways.
Yeah. God. Even just a full discovery docket.
Yeah.
Just basic. Forget evidence jurisdiction. Just standard discovery materials. Either not even given at all or just incomplete. Oh, this is what you get. We've satisfied every requirement we need to make.
Now, I don't want to confuse that during arraignment, your right is to be informed, which is slightly different than the right to discovery. It covers a lot of the same material and a lot of the same information, but it's a different perspective. And if you say I'm wanting discovery, it can be a little different. You're just trying to be informed. You have supposedly the right to be informed of all of it, what you're accused of, and to understand every bit of, well, I don't want to use the word understand, but be informed of every bit of the essential elements and what facts construct that you're guilty before entering a plea. It's kind of important and kind of something that's skipped. It's not just not just the code section that you're accused of. Like you're accused of 108 point whatever. No, it's you that is in charge of what information you're getting. And they'll give you the minimum, but you have the right to more, according to them, if you ask them. Now, if they say you have no right to any more, you can address that separately. See, it's about getting them to confess certain things sometimes, but we'll get into that some other time.
And again, even if someone never goes into court and says words like this, knowing this information is invaluable. Knowing the hustle before a lawyer knows you know the hustle.
Right.
Invaluable. When you'll be able to direct them in ways that no one else can. I want you to address this. I don't want you to cover this. I want you to object here. Why didn't you object there?
Well, I mean, that brings up a good point. A defense attorney or your attorney's job, number one, is to make sure there's no appealable errors. And sometimes you want appealable errors. If you've been screwed over, that appealable error is your saving grace sometimes. And for you to let a lawyer kind of negate that or waive that appealable error or fix it can be against your better interests easily. But generally speaking, they'll waive it. If there's some timeliness issues, boy, they'll waive your right to a speedy trial in a heartbeat.
Oh yeah.
Just to make the judge happier with them.
Well, I don't. People do that because they're told and convinced by their lawyer. Look, I know how to make this as least painful for you as possible, and part of that package is you need to sign a waiver to your right to speedy trial.
Right.
Say yes here. Say yes here. Say no there. Say no there. I know best. This is my job.
Oh,
I'm
I need more time. I need more time.
Yeah.
It's not them. I'm sorry, but put that prosecutor on his workload. Give him his workload. He wants to cut all kinds of corners in informing you.
Oh, yeah.
And there's a whole ton of work you can make him do during an arraignment or to complete an arraignment rightly.
Right.
But boy, man, those judges don't like to inconvenience their best friend, man, their golf buddy.
So don't ever give up rights. You don't have to, quote unquote, rights.
Yeah.
But keep in mind.
Well, at least know that you're giving them up for something you want, not something your lawyer
you're
wants,
getting something out of it,
or the judge wants.
But keep in mind too, like speedy trial doesn't really mean anything unless you're accused of murder or something super serious that they do not want to screw up on. They may not give it to you. It's supposed to be 6 months till the trial's over. Whatever. I've had stuff go on 14 months. Challenged jurisdiction the whole way. Never entered a plea. Never had a plea entered. And still, they didn't give a flying F about any right to a speedy trial. So
Right. All right. Oh, defense attorneys have a primary job to fight against appealable errors. This might often involve waiving a right that would benefit you. Hey, I repeat myself. Most commonly, timeliness and being informed. Hey, I just said that.
a defense lawyer is every bit your opponent as the prosecutor is. The advice that they're going to give you.
And the judge as well.
And the judge as well.
It's the system against you in a lot of ways. You're your only advocate on some points, like being informed, like speedy trial. There's a lot of them. All right. They also have a duty to their chain of command, which includes people who benefit from punishing accused people, right or wrong. They don't really care. There's a
They've got quotas too.
yeah.
I want the highest conviction rate possible. I'm the best lawyer around.
And there are more people accused and convicted than there are people that are guilty, and that's scary.
Yeah. Yeah. Especially when you consider nonviolent victim as crimes.
So malum in se versus malum prohibitum. It's kind of been the topic of the day here. Malum in se is when something is inherently wrong, and malum prohibitum is when something is forbidden. Now,
Regardless of its right or wrongness.
yeah, and there's this whole legal history about that difference and recognizing that difference, and this whole common practice of ignoring that difference and acting like it doesn't exist, because when it comes down to rubber meeting the road, they don't want it to exist. But when they're justifying it, like philosophically, they recognize it as being paramount and super important, but they don't want anybody actually standing upon justice and rights. They want to just use that word on the building. They don't want to use it in the room.
Whatever they title their buildings with, that's the opposite of what's actually going on in that building, right?
All right. Jurisdiction is a justified assertion to rightly impose upon someone. As opposed to power. Power to impose is a different issue, a different question. And permission to impose is also a different question. If it means anything, jurisdiction has to be related to right, has to be related to right and wrong, has to be related to justice. If it's not related to right and wrong and justice, it is just another word for power. All right, and we'll close with, he did mention briefly in there some fictional, legal fictions, I guess you call them. So the idea of a fictional party being present and harmed, it can't be part of a logical and just reasoning. Not if the person impacted by that delusion is objecting. So legal fictions are super common. And it's constructed to get one past you. It's a legal fiction. You should be challenging it or questioning it or investigating it if it's not decidedly in your favor and something you want. Dispensing with fictions is a very good idea in many, many instances. And lawyers do not want to dispense with fictions.
No.
Hardly ever. But that's half of why we don't understand what's going on half the time, is they've constructed all these fictional things. Now, legal fiction has another word. It's something that's not necessarily true. It can be something decidedly incorrect, and it can be something decidedly unethical. And if you don't have any objections to it, they'll go along.
Yep.
And even if you do have objections to it, they'll fight you to keep a hold of that fiction.
Oh, yeah.
And they'll say, oh, legal fiction. Well, it's not optional if it's a legal fiction. I was like, well, wait a minute. If justice is the goal, and a legal fiction introduces injustice, or introduces falseness, or introduces a lie, then it needs to be justified. And it can't be justified to introduce a lie.
And the biggest example is the state of blank.
Yeah.
Or United States of America versus.
Yeah.
Or
Yeah, he harmed the people. What people
it's
were harmed? Point one.
psychologically designed to make you feel that you're lone defendant against the masses.
It's like
the judge always says the court when he means me.
yeah.
I'm all these people. That's who you're
Yeah.
tangling with. It's just a manipulation. But further, again, if you're like, let's say, California, the state of California. Well, okay, State of California, there's a conflict of interest. State of California licenses the prosecutor, the judge, and the defense lawyer. If it's a public defender, the state of California also pays him, pays the judge, and pays the prosecutor. So I mean, that's a self-evident conflict of interest. And when that's been used, it's actually been one of the strongest arguments that, well, when I say strongest, I mean easily digested by the public watching.
Yeah.
It just doesn't make any sense. This is your accuser. Your accuser pays the judge. That is as fiction he gets.
And pays the guy who's supposed to be defending you against him.
Yeah.
In a sense.
Licenses that.
Yeah, licenses
that
them.
means coercion capable.
Yeah. He can
Pays.
remove his license, stop him from working tomorrow if he doesn't like what's going on today.
So, I mean, that is so powerful that on its own, forget the jurisdictional issue, delegitimizes the entire house of cards. To have that kind of a conflict of interest be so obvious.
But you can pay your own.
Okay, so you pay your own. He's still licensed.
Yeah, try to pay your own that isn't licensed by them for a minute.
His loyalty? Is it going to be to the bar and his image and his career, or is it going to be client number 12 out of 16 cases that I'm handling? Just top to bottom, just a house of cards.
All right. And to reiterate, does a court have jurisdiction over an innocent person who's accused of a crime but unwilling to be subject to a court? And most lawyers will answer yes to this. And if so, then by what principle, except might makes right, would that be? So it has to come down to might makes right. If you're accusing an innocent person and dragging him into court against his will, then it has to be might makes right that's at play. Now, they'll hide it in a million different ways.
Oh, yeah. It's got to be pretty. You got to have consent of the government. It's the same reason why we all have to accept that taxes are coming out of our paycheck. It's the only reason why we pay taxes. Nobody would pay a penny more than they had to unless the threat of violence.
Well, let's pretend you consented. You consented in an abstract political group way.
Lord. No one would realistically do that. Even if they had control over how the money was spent, they'd say, no thanks. If it's optional, I'm not paying income tax.
Right. Now, if they say, I'll pay 10 cents and my neighbor pays $1, they might find that to be okay. In fact, I see a lot of people finding that to be quite okay.
Oh, yeah. I mean, how much did Amazon pay in taxes after making so many billions? 0.
All right. Well, a lot of ground covered there. But see, all of these rabbit holes go so much deeper. And
hours and hours and hours and hours and hours.
And we have a lot of videos in the past dealing with certain issues.
Those videos exist.
Yeah. Well, hopefully we'll come down to getting them better organized or get the topics better recovered maybe in character. But anything you'd like to close with?
Yeah, just a little update for the viewers. So we're right now just putting out some core fundamentals. We're just uploading a few videos that just have to do with the basics so that when we start really getting into the game here, that people have a foundation to come back on when they ask, who are these two and what do they think and why? But eventually we're going to get to ideally like a live call-in show. We've got everything getting set up and even screened calls. So it'll be nothing but as interesting a story. How do I say this? The most interesting stories we can get our hands on, get our ears on.
Yeah.
So that's kind of what's coming. And then also just live streaming interaction between, subscribers and ourselves and going down that road. But with a heavy dose of MGTOW, it's coming. Get ready. It's coming.
Well, excellent. Thank you for heading out, and let's do this again soon. And
Yep. Tuesdays, Thursdays, or anytime on the weekend.
Outstanding. I'll work on that again. All right, guys. Talk at you again soon. Bye-bye.